The case with Engle v. Vitale had to do with a school prayer. So, New York State Board of Regents had developed what they considered to be a non-sectarian prayer that could be used, that it was recommended. It didn't privilege any religion, they felt, and it was only 22 words long. All right, so here's the entire prayer. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. All right, so that's the scope of the prayer. And again, it was recommended. And so the Union Free School District in New Hyde Park, New York, decided to use this prayer and have teachers pray it. Stephen Engle and other parents objected to this. Went to the Supreme Court. In a 7-1 decision, the Supreme Court argued that prayer was inherently religious, so that basically disqualified the prayer. The prayer does not belong in public schools because it would be an establishment of religion. So Engle v. Vitale essentially eliminated prayer in public schools. Another case adopted something similar with respect to Bible reading. So Abington Township versus Chimp had to do with Abington Township was in Pennsylvania, and essentially had a practice of reading at least 10 verses from multiple versions of the Bible without comment. So it was essentially, reading from a Catholic version, reading from a Protestant version, reading from a Jewish version. In some cases, it was also reciting the Lord's Prayer. So Edward and Sidney Chimp had 3 kids. One of them was named Ellery Chimp. And so they didn't particularly like this. They were Unitarian family. Now, the program had an opt-out clause, right? Parents could opt their kids out of the program. They could opt them out of the Bible reading. So one day, Ellery Chimp brings a Quran to school, and so they do the reading. Chimp reads from the Quran, and he is sent to the principal's office. And so he gets in trouble because of this. So, the Chimp family as well said, if their kids opt out, they would look like atheists or communists or atheistic communists. But essentially this caused problems for parents and kids that didn't, think that this was a good practice. And Ellery Chimp is still alive and is actually an atheist today. But the Supreme Court decided in an 8-1 decision that the law or the practice was unconstitutional, essentially eliminating Bible reading from public schools. Part of the problem for the township, or part of the problem for the state, was that they had allowed opting out. If this was truly a neutral character building experience, plus the fact that they used a variety of translations acknowledged that what they were doing was religious. That if they didn't allow the opting out, if they only used one translation, the argument may have been made successfully that this was more about character and morality and not about religion. All right, so that was they'd kind of essentially worked themselves into a situation where that was found to be unconstitutional, and the idea was you knew it, which is why you tried to get around that. Another important case was Lemon v. Kurtzman. Kurtzman, this also in Pennsylvania, Kurtzman was the superintendent of public instruction of Pennsylvania, and Alton Lemon was a taxpayer and had children in public school in Pennsylvania. Now, both Pennsylvania and Rhode Island had developed a law that essentially paid for private school teachers' salaries when not explicitly sectarian. So if a private school was specifically a Catholic school or a Baptist school, they didn't pay the salaries then. But if it was generally private, may have even been religious, but was not particularly connected with a denomination, they paid for the teacher's salary. Ultimately, the Supreme Court decided against this, that this was problematic, and out of that developed what became known as the Lemon Test. It was meant to be a judicial procedure by which justices would determine whether something was constitutional or not, whether it created an establishment of religion or not. Since Lemon v. Kurtzman, it has been applied at some times, and other times it's not been applied. So, and then there's some justices in more recent years that have not thought that this was a good test, and said no, this shouldn't be used. But essentially, the Lemon Test was a way to determine whether something was constitutional or not. And so a program or a law is constitutional if it has a fully secular purpose. Now, something has to meet all three of these criteria. So it has to have a fully secular purpose. It does not advance, nor does it inhibit religion. All right, so it doesn't encourage religion, it doesn't prevent religion. And then finally, it's constitutional if it doesn't create excessive entanglements of government with religion. Well, the issue for Lemon v. Kurtzman, they felt, was specifically this third one. There was some question about the first one, whether it was truly secular or not, but it really created kind of an entanglement of government with religion, because here was a government paying these private school salaries, and for these religious schools, even though they weren't specifically connected with a specific religious movement, a religious group or denomination. So the Lemon Test then gets used in a couple of other situations, but doesn't always get used consistently for the next several decades. We touched on this case already when we were talking about the rise of the religious right, Bob Jones University versus the United States. The IRS made a decision in 1970 that racially discriminatory policies rendered an institution no longer charitable. Right? So if you had racially discriminating policies, you were not a charitable organization, and so you weren't allowed to have tax-exempt status. It wasn't until 1971 that Bob Jones started admitting African Americans, but there were other policies that did not allow things like interracial dating. There were limitations as to where African Americans could live in the dorms and that kind of stuff. And so it wasn't just, prior to this, of course, they weren't admitting African Americans, and so that was problematic. But then also the policies that were restrictive of African Americans, were problematic as well. And so the IRS decided in 1976 to revoke their tax-exempt status and made it retroactive to 1970. Right? So there's like, you have these 6 years you have to pay taxes, which would have been probably a sizable amount of money. Ultimately, the Supreme Court decided in an 8-1 decision to support the IRS's finding and argued that public policy could override religious convictions, especially when it came to something like racial discrimination. So, it'll be interesting to see if some of the recent decisions related to sexual orientation and gender identity will also then be used in a similar type of way for institutions in the future. But for now, it's predominantly been related to racial discrimination. So we'll see what happens further. Let's talk about some other school cases. Wisconsin v. Yoder in 1972 involved 3 families. A couple were Amish, one was Mennonite, and they wanted to educate their children according to their religious beliefs, and so they wanted to withdraw them from public school. Now, Wisconsin had a law that was essentially compulsory education until the age of 16. So all families had to put their kids in public school until the age of 16. Well, the families withdrew their kids after the 8th grade before they were 16. So they were convicted in county court and fined $5 each. Well, the lower courts upheld the law, saying that it was a reasonable and constitutional use of government power. Well, it went to the Wisconsin Supreme Court, and they overturned it. And their argument was, this is the Wisconsin State Supreme Court, they didn't believe that Wisconsin's law demonstrated why the free exercise of religion should be overturned. Why is this law a compelling reason? What's the compelling reason that this law should overturn religious freedom? The state appealed it to the Supreme Court. The Supreme Court decided 6-1 in favor of the parents. One of the things that was kind of expressed in the case was, what would compulsory education do to the Amish way of life? Right? With the belief that it would essentially destroy it. Would it essentially destroy the Amish way of life if there wasn't the openness to allowing parents to educate their children in their own way in their religious tradition? Another case here in connected to Alabama was Wallace v. Jaffrey. Wallace was the governor of Alabama at the time. Ishmael Jaffrey was from Mobile and the father of 3 students in the Alabama school system. So Alabama created a one minute moment of silence for public schools at the beginning of the day. That every day as school started, there would be 1 minute of silence, and during that time, people could pray, they could meditate, they could do nothing, right? If they didn't really particularly want it, but there would be 1 minute of silence. It could be used for prayer, didn't have to be. Jaffrey was an agnostic, and so in his kids didn't participate in the prayers, and he said that, well, the youngest had actually been made fun of for not saying the prayers. The U.S. District Court upheld the law. But when it went to the Supreme Court overturned the law, specifically pointing to the Lemon Test and saying, all right, the law did not have a secular purpose, right? So immediately fails the Lemon Test. They further pointed out, right, that the person that sponsored the law, the person that kind of introduced the law, specifically said it was a way to get prayer back into public schools. Right? Even though it was meant to be voluntary, that because he specifically said, right, this will be a way to get prayers back into public schools, it's religious, kick it out. Right? So again, legislative intent, very important, as well as the question of the Lemon Test. Another issue of school prayer came up in the case of the Santa Fe Independent School District versus Doe in 2000. Santa Fe here, a town near Houston, Texas. So the school district allowed the students, decided, all right, we're going to have students vote on whether or not they wanted prayer before sporting events, right? Before football, for example. And if the students voted yes, then they would also vote on who would be the person to pray. Now, the guidelines were going to be, it's supposed to be a non-sectarian prayer, just a very generic prayer, probably something similar to, what the Regents, the New York Board of Regents had tried to create. Just a very, God, we thank thee for, your blessings. Please protect everyone as they compete. Right? Amen. So very sectarian, non-sectarian prayer. The Does, they didn't use their last name. Right? Doe is just kind of a pseudonym here. One was a Catholic family, one was a Mormon family, and so they sued to try and stop it. The school district never actually voted, right? So they sued before that to prevent it from happening. Now the school district argues this is not a state action, right? This is not the public school, acting here. The student body was going to choose whether or not they wanted prayer, and the student that was chosen was going to be given the prayer. It wasn't going to be a teacher. It wasn't going to be an administrator. Supreme Court ruled 6-3 that it was government speech because it would be on school property at a school event over a school-owned loudspeaker controlled by school officials. And the election itself had been created by the school. Right? This wasn't a student-motivated decision. It wasn't the student said, hey, we want to find out if we have a prayer before a football game or not. No, there was the school district that decided that. Additionally, for some students, the team, the cheerleaders, the band, they were required to be there. Right? So they didn't have the opportunity to opt out of this. You could say, well, fans don't like it, they can show up late. Yeah, but there's some of those kids wouldn't be allowed to do that. Right? They had to be there at a specific time, and so because of all that, the Supreme Court ruled, the majority decided, right, that this was a school event. This was government speech, so it was an establishment of religion, and so it wasn't allowed to go through. Remember, the school district actually never got to the point of voting on this. They might have voted to not do the prayer. Unlikely, but that was the decision. A recent case, this one just recently decided within the past year, related to school, had to do with whether or not the government can get involved in religious schools making personnel decisions. Right? That, if you work at a regular job in the secular field and you are dismissed from your job, you're fired from your job because of your sex, because of your age, because of your religion, because of your race, there are legislative opportunities open for you to sue your employer, right, against discrimination. So Agnes Morrissey Baru claimed that she had lost her job at Our Lady of Guadalupe School due to her age rather than her performance. The school claimed it was her performance. She says, no, it's really because, my age, because they're trying to hire somebody younger. It had been combined, this case was combined with another case in a nearby area that involved a teacher named Kristen Beale, who worked at a school called St. James. She claimed she was fired because she requested a leave of absence because she had breast cancer, and so she was going to be treated for breast cancer, needed to take some time off, and the school fired her. Now, the school claimed they fired her because she didn't follow the curriculum, and she didn't keep an orderly classroom. Both schools, Our Lady of Guadalupe as well as St. James, were part of the Archdiocese of Los Angeles. Right? So this is a Catholic institution. So both teachers sued their appropriate schools. By the time it got to the Supreme Court, the cases were merged, since they were so similar. Our Lady of Guadalupe especially claimed that this situation fell under what's called a ministerial exemption provision. There was a previous Supreme Court case that basically said some teachers in church schools should be considered ministers. And so the Supreme Court had decided that since government should not get involved in the hiring and firing of ministers, they shouldn't get involved in the hiring and firing of teachers in that specific situation where there were some teachers were considered ministers, and so any allowance of awards, right, giving them money or other types of things to fulfill their case, punished the church. So this was the inhibiting of religion, and that was this other case that they decided. And so Our Lady of Guadalupe is arguing our situation fits this. But both Morrissey Baru and Beale weren't necessarily considered ministers. The previous case, some of the teachers were considered ministers. So when the U.S. Ninth Circuit Court got this case, right, when it went to the U.S. Ninth Circuit, they said the ministerial exemption doesn't apply in this case. We're not talking about it, and so they did have the right to sue for redress and to get some benefits, some money from the case, from the schools. When it got to the Supreme Court, they overturned that ruling and said that the free exercise clause of the Constitution allowed for the firing of both women without the ability to appeal to various discriminatory policies, etc. And took a very broad exemption approach that basically, because both teachers provided religious education, right? They were elementary school teachers, so they did some teaching in religion. They prayed with their students. They did a variety of other things that were religious in nature. So even though they weren't specifically named ministers, the case fell under the ministerial exemption. Now, some of the justices, remember it was 7-2, so 2 dissented. They felt this is making this way too broad. Right? The ministerial exemption is being made way too broad. It was just supposed to be about the ministers, right, keeping out of churches, but now we're broadening it to schools and other things. So there's concern about how broad this is being made. I'm going to talk about some more school cases, but specifically ones related to the teaching of evolution or creationism in public schools. We talked a little bit about this when we talked about the Scopes trial, but we didn't. We talked about the Butler Act and things like that. And so some of this is connected with some of the fallout of that. One of those is Epperson v. Arkansas. So Arkansas in 1928 had created a law which was very much like the Butler Act, and it prohibited the teaching of evolution. So in 1965, a Little Rock school district adopted a textbook that included evolution. Susan Epperson, who was a new biology teacher, was a little concerned about this, right? Is she going to be, arrested? Is she going to be fined? The law had never been enforced, but, there was some concern. So the Arkansas Education Association had kind of basically decided to challenge the law and asked Epperson to participate in this. And so she asked for summary judgment. Now, Epperson was religious. She was a Presbyterian. I believe she's still alive, and she's still Presbyterian. And she actually ended up meeting John Scopes after the trial was over, not during, but after. So she asked for summary judgment, a decision about, is this law constitutional? Will I be subject to punishment? Well, the Chancery Court, which is a lower level court, said the law's unconstitutional. Right? It's not constitutional. So the state appealed to the Arkansas Supreme Court. The Arkansas Supreme Court overturned the lower court ruling and said, no, the law is valid. So Epperson appealed to the Supreme Court. The Supreme Court unanimously said the law is unconstitutional. That essentially the law advanced religious beliefs, it promoted religion, and so basically making anti-evolution statutes unconstitutional. That, if a state tried to prohibit the teaching of evolution, that was unconstitutional. All right. So that was Epperson v. Arkansas. A couple of years later, there was a slightly different case. So in 1981, Louisiana Governor Dave Treen signed the Balanced Treatment Act, which Arkansas had developed a similar law as well, but this is Louisiana. If evolution was taught, creation science also had to be taught in public schools, right? So if you're teaching the one, you have to teach both. So Donald Aguilar was a high school biology teacher, and he was joined by other teachers and parents to challenge the law. The district court ruled in Aguilar v. Treen in 1985 against the law, essentially saying creation science was religious doctrine. Now, an Arkansas district court ruled similarly in McLean v. Arkansas in 1982. In 1983, Edwin Edwards became governor of Louisiana, which is why it's Edwards v. Aguilar, because the decision was appealed to the Supreme Court. And so now it was against Edwards as governor. The Supreme Court used the Lemon test in this situation and ruled 7-2 that the law was unconstitutional. The law had no secular purpose, and it promoted religious belief, according to the justices. Right? So creation science was not allowed to be taught. Right? So first, you can't have an anti-evolution statute. Then you can't teach creation science. Well, in 2005, the question of intelligent design came up. So the Dover Area School District in Pennsylvania incorporated intelligent design into the curriculum. This was a decision by the school board. And it required teachers to read a statement that evolution was a theory that they were required to learn, because of the Pennsylvania academic standards, but there were other options, including intelligent design, and then reference was given to an intelligent design book called Of Pandas and People, and students were encouraged to keep an open mind. Well, a lot of the professors, refused to read it, so a school administrator was the one that actually read it. The ACLU helped 11 parents sue the school district. Tammy Kitzmiller was just one of those parents, was listed as the lead plaintiff. In November of 2005, there were school board elections, and all the board members who had supported this statement and supported the teaching of intelligent design were not reelected. A district judge ruled against the school district and said this violated the endorsement test, and that public statements by members of the board, as well as other actions that they had taken, indicated that the policy was established for religious reasons. Now, ultimately, it couldn't be appealed to the Supreme Court because, at this point, there was a new board who rejected the policy, and so there wasn't anything to appeal because the school board had gotten rid of the policy at this point. And so that's been, the ways in which people have looked at the, the issue of creation science and evolution in public schools. Just briefly want to touch on a couple of cases involving the display of the Ten Commandments or nativity scenes on public lands. One of those is Lynch v. Donnelly in 1984. This was the city of Pawtucket, Rhode Island. The city co-sponsored with merchants, local merchants, a Christmas display. And the city set up a nativity scene. And the mayor specifically said that he wanted to keep Christ in Christmas. And the Supreme Court ruled 5-4 that the city had a secular purpose, despite the mayor's claims, and that they were celebrating a secular holiday, so it wasn't a problem. But in a later ruling, 5 years later in 1989, it overturned it. So, ruling against the idea that cities can set up nativity scenes because they are inherently religious. When it comes to the Ten Commandments, I'm going to talk about a couple of cases, just briefly. McCreary v. the ACLU in 2005. There had been a setup of two displays of the Ten Commandments in county courthouses in Kentucky. So, two separate courthouses. They were put up by religious conservatives, essentially to kind of claim the Christian heritage of the United States. Right? The Ten Commandments were important in the founding of laws. So, lower courts ruled the displays were unconstitutional. So the two counties included other documents, right? So not just the Ten Commandments, but other documents that were solely religious documents. That was found to be problematic as well. So they tried a third time, including other documents that didn't specifically include references to God, right? So you have the Ten Commandments, these other religious documents, and then some documents that weren't inherently religious. Made its way to the Supreme Court. Supreme Court decided 5-4 against the displays, that they needed to be removed because they violated the Establishment Clause, again, using the Lemon Test. This was a case of one of the justices, Antonin Scalia, who just died recently, past year or so. He was against the Lemon Test and against the idea of there needed to be government neutrality. A slightly different ruling was made the same day. Right, the same day McCreary versus ACLU was decided, Van Orden v. Perry was decided. And it had to do with display in a public park near the Texas Capitol. Van Orden was the one that sued the state of Texas. Rick Perry was the governor of Texas at the time. Van Orden had actually been a lawyer. I don't think he was a lawyer at the time he sued. But it had to do with a marble monument of the Ten Commandments that had been erected in 1961. Ultimately, the Supreme Court decided it could stay. And one justice actually argued that the age of the monument gave it legitimacy. So he was the swing vote. Right? In McCreary v. ACLU, he said they needed to go. But in Van Orden v. Perry, he supported it staying, right? So that's why, I mean, they were both 5-4, but in one case they had to go down, in another case they could stay up because of the issue of age. There have also been some Supreme Court cases that have dealt with what we might consider to be moral issues. Dealing with questions related to abortion, specifically contraceptives, as well as same-sex marriage. Now, there have been other cases related to same-sex marriage that broadened the rights and essentially eliminated state rulings against same-sex marriage, but they haven't specifically been religiously oriented. And so we're not going to talk about them. Instead, we're going to talk about ones where there's a religious connection. The first one we'll talk about is Burwell v. Hobby Lobby. So when the Affordable Care Act, sometimes referred to as Obamacare, was passed in 2010, there was a provision in that act that required employers to provide insurance plans that covered contraception if they provided insurance, right? So if you provide insurance to your employees, you needed to have a plan that covered contraception, and if you didn't, you would be fined. Now, some of the contraceptives that were in the list, some people felt were abortifacients, meaning they essentially aborted a fetus. And so there were concerns about, for some people, about whether or not this was supporting abortion. So Hobby Lobby filed suit claiming that these types of contraceptives were against its owner's beliefs. It was joined with a couple of other companies, including the Conestoga Wood Specialties, which was owned by a Mennonite family. In both cases, we're talking about privately owned companies that had very small number of shareholders. They weren't widely owned by the public, publicly traded on the stock market, for example. Now, the original appeal to the Supreme Court to block enforcement of the Affordable Care Act provision was rejected, but eventually came up through. Now, some other decisions had been made that essentially a corporation could be considered a person under the law, which opened up a lot of opportunities for certain types of corporations to experience certain types of freedoms. And previous cases had used similar reasoning for particularly nonprofit corporations. So in this case, the decision was 5-4 that the Affordable Care Act provision for closely held corporations, not all corporations, but closely held corporations, where there were a small number of shareholders, did not have to or could be exempted from that requirement. Now, they didn't really address the free exercise claims that Hobby Lobby had put forth. But they argued that since the government had provided exemptions for other organizations, that closely held corporations could also be allowed to be exempt. A similar case took place in in Washington State, which involved pharmacies and what pharmacists might be willing to provide related to contraception and certain drugs. So Washington State had created a law that pharmacists could not refuse to provide a drug to a person, specifically, quote, because its owner objects to delivery on religious, moral, or other personal grounds. Right? So just because you as a pharmacist might have a moral objection to a certain drug, that did not exempt you. You had to provide that drug to a person, if it was, properly prescribed, etc. Right? It wasn't just, somebody comes in and asks for a drug and you give it to them. Right? If their doctor prescribed it, or if it was a over-the-counter medicine, then etc. So Ken and Lynn Storeman owned a pharmacy. And they refused to provide a pill called Plan B, which was a contraceptive, which they believed was an abortifacient, right, that it caused an abortion. Originally, the law was struck down, but later was upheld on appeal. Now, the Stormins were willing to refer customers to other pharmacies, and actually, there were several in a 5-mile radius of their store. Well, ultimately, the law allowed the right to refuse drugs to people who couldn't afford it or had insurance plans the pharmacy didn't accept, like Medicaid, right? So a pharmacy could refuse to accept Medicaid and essentially was refusing to provide drugs to that person. However, the Supreme Court ultimately declined to take the case. So, the law was upheld because it wasn't, it had been upheld by lower courts, but the Supreme Court didn't intervene. You need to have 4 justices agree to take the case, and 4 didn't. But one of them said that he would have taken it, and he felt that they had the right, that the law should be overturned because people should have the right. These other situations, you could refuse to provide drugs. Similar situation with the Little Sisters of the Poor Saints Peter and Paul home versus Pennsylvania. So after the Hobby Lobby decision, the Department of Health and Human Services created a form where certain groups could file the form with their insurance companies noting their objections to the contraceptive mandate. The insurance company would then provide contraceptive coverage directly to individuals rather than through the employer. Now, the Little Sisters of the Poor ran 25 houses for low-income elderly people, and so they could qualify for this exemption. But they believed that even filing the form would make them complicit in contraceptive coverage. As Catholics, they followed church teaching. Not everybody that's Catholic accepts the church teaching about contraception, but it wasn't entirely about abortifacients. That was part of it, but contraception in total was something that Catholic teaching was against. And so they said, well, we're still indirectly providing contraception even if we file the form. Well, they were granted an injunction against the support of the law, or the inaction of the law, and other groups filed similar cases. Well, they were all consolidated into one case called Zubrick v. Burwell. Well, as the case made its way to the Supreme Court, Justice Scalia died, leaving 8 members of the court. Well, 4 conservatives, 4 liberals, the court was split. The cases essentially were vacated and remanded to the lower courts. Shortly after he became president, President Trump issued an executive order that changed how the government developed the regulations to address the issue. Well, some of the states challenged the new rules. Right? There were court cases, injunctions, appeals, right? All made its way to the Supreme Court. Ultimately, this second time through, the Supreme Court ruled 7-2, allowing these new rules which exempted employers with religious or moral problems with the contraceptive mandate. So they essentially said, if you have a religious concern, you do not have to provide insurance that has contraceptives included with it. Now, the dissenting justices argued that basically allowed religious belief to overrule other rights that people had, especially those that did not share their beliefs, did not share the beliefs of other people. Then there was the Masterpiece Cake Shop versus the Colorado Civil Rights Commission. This is a same-sex marriage situation. So Jack Phillips was the owner of a bakery, Masterpiece Cake Shop, and a same-sex couple came into his shop wanting him to make a custom cake for their wedding. Now, Colorado at the time did not recognize same-sex marriage. This is before the Supreme Court decision that overruled those decisions. Right? But at the time, Colorado didn't recognize the legality of same-sex marriage. So they were actually going to go to Massachusetts to get married, wanted to come back to Colorado where they lived and have a cake for a celebration there. Well, Mr. Phillips refused to make the cake. So the couple filed a complaint with the Colorado Civil Rights Commission that the bakery had violated the Colorado Anti-Discrimination Act. Well, Phillips claimed it would violate his First Amendment rights, both speech and religion, for him to make the cake celebrating a same-sex wedding. The case made its way to the Supreme Court, and they ultimately decided in favor of Phillips, saying, it wasn't that he refused to sell all products to gays, only that he refused to use his talents to support gay marriage. Right? So he wasn't, he would have given them a regular cake. They could have, gotten all sorts of other things, but to create a custom cake is where Phillips said, no, I can't do that. Another part of this as well is that the Civil Rights Commission members had been very negative towards Phillips and his beliefs instead of being neutral to them, which was an important part of some of the previous acts related to religious freedom. The last thing we'll close with are 2 cases related to the pandemic, and particularly some of the limits that have been around because of health concerns and executive orders prohibiting gatherings. One of those was in California, South Bay United Pentecostal Church versus Newsom. This is California Governor Gavin Newsom, who had issued an executive order limiting attendance at places of worship to 25% or to a maximum of 100 people. Right? So, 100 people was the max. So South Bay United Pentecostal Church in San Diego sued, made its way to the Supreme Court, very quickly, and so the Supreme Court denied the motion for relief, 5-4. Said, in the majority they said the same restrictions applied to secular venues, so those are the decisions. Government has responsibilities and authority regarding safety and health. Now, some of the dissenters, the 4 dissenters, felt right? This is discriminating against religion, but the majority felt that it wasn't. Slightly different decision made in the Roman Catholic Diocese of Brooklyn versus Cuomo, Andrew Cuomo, governor of New York. He had issued an executive order that limited worship gatherings based on a color-coded zone system. And so different zones were color-coded based on the amount of COVID infection. Red zones, where there was high COVID infection rates, were limited to 10 people, orange zones 25 people, other zones, etc. It was appealed by the Roman Catholic Diocese of Brooklyn, as well as the Aguilar Israel of America, which was an Orthodox Jewish congregation. So their suits were kind of combined. It's still kind of being considered in the Second District Court, but the Supreme Court was asked to block enforcement. All right, so the court decision, hasn't made its way to the Supreme Court, but the Supreme Court stepped in to block enforcement. The case hasn't officially been decided. It's just the Supreme Court stepped in to block its enforcement, 5-4 as well. So the opposite decision than the Newsom case. So it's still working its way through the courts. But essentially, the 5 justices believed that the First Amendment claims would prevail in the Cuomo case. That essentially Cuomo's executive order did not show neutrality because there were not similar restrictions on certain other businesses, like big box stores, liquor stores, etc., which were also considered essential. And so kind of a slightly different view here than the one that was the case in California. So that's a wide view, a very broad view of all these cases, and again, just touching the surface of all sorts of cases that have come up before Christianity in the courts. And so, there have been sometimes Christianity and religion in general has been, supported, established almost, and other times, Christians have been, some of their what they believe to be their religious freedoms have been blocked. And so really interesting kind of back and forth we see as people trying to make sense of what role does Christianity have in the United States, especially when it comes to issues of church and state. And I imagine that will continue to be the case here in the future.